definition was included as people who love sausage and respect the law. Arbitration Institute, yours or ours, or ours, etc.
Speakers, colleagues, all representations. I'll be a little bit pressure must be somewhere near to your shoes.
No.
So I'm trying now to add to
panel. From our distinguished panel, who without a doubt will discuss important. I believe that Kosovo has put in place the necessary infrastructure for efficient and user-friendly arbitration proceedings. First of all, the legal framework. We have a sound arbitration law, which, although adopted back in 2007, due to the functioning of institutional arbitration in the country, has been serving as lex arbitri, or the procedural law, only for the past 5 years. The law on arbitration, which lays down the same regime for both domestic and international arbitration, is squarely based on UNCITRAL model law on international commercial arbitration. Second, the procedural framework and the arbitration facilities. Today, we have a sound procedural framework with arbitration rules that were tested and used in several domestic and international arbitration cases.
Here because on our side is some external factors, and I put on the first line of my ranking list the economic and financial power of the area, which is International Arbitration Acts, is very important, and in regard to Slovenia, I must say the things are going in the right direction. But I would like to interpret also a broader community towards arbitration, and I will give you an example. Third line, does a state have a benefit for arbitration? I apologize, this question is superfluous, because a right answer is double yes. Arbitration in the Adriatic region have a future.
Arbitrations. But before I do that, it is crucial for me to possible divorce. I know that it sounds unnatural, but that's the way it is. Certain developments, and we took into account these latest developments in arbitration law.
Why is it important to choose the seat of arbitration diligently at the outset? And on what basis should business people, legal counsel, and other stakeholders make such a decision? Firstly, let me say that the importance of selecting of the suitable seat for an arbitration cannot be overstated, because this choice may impact the arbitration in various ways. It may have very important and serious legal consequences. The legal seat is the juridical link to the arbitration proceedings, and the consequences are, for example, which law should apply, lex arbitri, like Anniversay said at the very beginning. It determines the jurisdiction of the courts that have the competence in certain situations to intervene in arbitral proceedings. It will have an impact on the enforceability of the arbitral award, and that is the very aim of the arbitral process.
Giving it an international, let's say, a bigger international. Another way, here I'm speaking from my in Kosovo. According to the arbitration rules, cannot be enforced in Kosovo.
I consider business as a huge engine, and the business people as the persons which stay on the wheel, and depends on them how they drive the business. So it depends on the business people on how fast the business is driven, and whenever there is any issue, likewise a dispute, how they want to resolve the dispute, what could be the fast solution, and as well the solution that resists the time. And I'm still repeating, arbitration is the right choice.
Poland, Warsaw, and numerous others.
Applies to this arbitration agreement is if the parties determine themselves.
We need to reform Kosovo arbitration law to be better suited to international commercial transactions and international commercial arbitration, because we have some gaps. But when we drafted the law, we were pretty sure that we will find gaps, and I think it's time to take stock. Perhaps our arbitration law has not incorporated the 2006 revision of the UNCITRAL model, so we have a defect there. And yes, we wrote a paper on this, but nobody really took notice of it, so it's okay. So the next point is, well, we have some issues which are really specific to international commercial transactions in respect of what we call conflict of laws, or which is commonly known private international law. Private international law is something which, even for the shrewdest lawyers, is something very exotic.
And international arbitration. It's in the same line. We don't have a division.
Assembly of salaried person
that is familiar with arbitration are, in practice at least, favors.
Law, we might be in trouble when it comes to enforcement.